this video, we will be discussing about the Commercial Codes Act 2015 and the Code of Civil Procedure Amendment Act 2015. So in my first video, I had discussed about the background of Code of Civil Procedure in India, its evolution and the amendments till the year 2002. After 2002, the fourth amendment which came in Code of Civil Procedure 1908 was in the year 2015. All the amendments which are majorly brought in the Code of Civil Procedure in the year 2015 are for the adjudication of commercial disputes and for the procedures provided for the Commercial Codes Act 2015. First, we will discuss about the reasons behind the enactment of Commercial Codes Act. The codes which are mentioned in the Commercial Codes Act, the disputes which can be taken to the commercial codes and some of its major provisions. After that, in the second part, we will be discussing about the amendments and the new concepts which were introduced in the Code of Civil Procedure through the amendment in 2015. So there are four codes mentioned in the Commercial Codes Act 2015. First is Commercial Codes, second is Commercial Appellate Code, third is Commercial Division in the High Court, and fourth is the Commercial Appellate Division in the High Court. All the disputes which can be taken to the commercial courts are: first is all the disputes arising from the ordinary transactions between the traders, merchants, bankers, financiers, etc. Secondly, all the issues arising from the maritime and admiralty law. Thirdly, all the disputes arising from the transactions for helicopters, aircrafts, its machineries and engines. Fourthly, all the contracts and agreements of the commercial nature. Now we will be discussing about some of the major provisions which are included in the Commercial Codes Act 2015. The plaintiff shall exhaust the pre-institutional remedies of mediation. It is expressly mentioned in the Commercial Codes Act that the plaintiff shall exhaust his pre-institution mediation remedies before instituting the suit directly into the commercial courts. Second major provision is for the disposal of appeals. It is expressly mentioned that the appeals shall be disposed of within 6 months of its institution. Thirdly, it is mentioned that there shall be overriding effect of this act, which is the Special Act of Commercial Codes Act 2015 over any rules made by the High Court or the provisions of the Code of Civil Procedure 1908. Fourthly, it mentions about the collection and disclosure of data. So all the statistical data of the suits, applications, appeals and writ petitions instituted in the commercial courts shall be published in the website of the High Court every month. And secondly, all the cases disposed of by the commercial courts shall also be published in the website of the High Court. These are some of the major provisions of the Commercial Codes Act 2015. And now we will be discussing about the Schedule 1 of the Commercial Codes Act 2015. In Schedule 1, all the provisions and amendments which are brought in the Code of Civil Procedure 1908 for the procedures of commercial disputes are given, for which you can find the document in the description of the video. Now we will be discussing about some of the major amendments brought in the Code of Civil Procedure for the procedure of commercial disputes and some of the new concepts which are introduced in the Code of Civil Procedure through this. So the amended provisions in the Code of Civil Procedure for commercial matters states that the written statements shall be filed within 30 days of the institution of the suit by the plaintiff. The defendant has to file the written statement within 30 days, which is extendable to 120 days under certain circumstances, which shall be reasoned before the court by the defendant. Secondly, there is a provision for arguments, that the arguments shall be concluded within 6 months of the institution of first CMH, which is court management hearing, which we will be discussing further in the video. Thirdly, there is a provision for judgment, that the judgments shall be pronounced by the court within 3 months of the conclusion of the arguments. Fourthly, there is a provision for appeal that the appeals from the orders and judgments shall be filed within 60 days. The next provision states that each arguments for the pleadings shall be verified by the affidavit. The next provision is for costs. It states that every unsuccessful party shall compensate the successful party for all the expenses they have incurred, which includes the legal expenses for instituting the case, the court fees, and other expenses which are incurred by the successful party for the suit. Now we will be discussing about the new concepts which are introduced in the Code of Civil Procedure through the amendment of 2015 for the commercial dispute. The first one of it is the e-codes, which are also called the pilot projects for the Code of Civil Procedure Amendment Act of 2015. We can consider this as the onset of digitalization of Indian judiciary. So what are e-courts? Through e-courts now it is accessible for the parties and for the advocates and for us as general public to view the cases which are going on in the court. Secondly, there is a provision for electronic records. So previously also electronic records were admissible through the amendment in the Indian Evidence Act of 1872 and through the Information Technology Act of 2000. Thirdly, there is a provision for summary judgment. Summary judgment is the new concept which is introduced in the Code of Civil Procedure 1900. In this case, either of the parties can request for the summary judgment in the case and dispose of the matter. As there is no merit by both of the parties to win in the case, there is no merit by the plaintiff to succeed their claim, and there is no merit by the defendant party to defend their claim. Fourthly, there is a new provision for the CMH, which is Court Management Hearing, which is also called as Court Management System. This concept is adopted from the abroad law. It is a crucial process introduced to streamline litigation, ensure timely resolution of commercial disputes, and optimize the use of judicial resources. CMH aims to expedite the litigation process by identifying the key issues early on and encouraging the parties to explore alternative disputes resolution, which are ADR methods, including the mediation, setting clear timelines for different stages of the case, and ensuring adherence to those timelines. CMH must be held within 4 weeks of the admission of the affidavits and the denial of the documents by both the parties. So this is all for today's video, and if there is any questions regarding the video, then you can ask in the comment section below.